So the Supreme Court ruling on hijabs last week has caused quite a bit of uproar. So let's take a look at just where it began. And this has been something that has been long coming, with the reactions that have been varied. In order for us to understand more about it, we need to understand where it all began. So let's start, first of all, with all of this that took place last week, but it is a 5-year-long court battle that started in 2014 in Isiolo County. Now, let's take a look at the parties that were involved in this case. First was the Methodist Church, which runs the St. Paul's Kiwanjani Mixed Day Secondary School. They were the original petitioner. On the other side of this court battle was the Teachers Service Commission. Also, there was the County Director for Education and the District Education Officer, both of Isiolo County. These were the first, second, and third respondents. Now, the person at the heart of this dispute, though, was the parent, Mr. Fugisha, who applied to be an interested party in this case. So, according to court documents, this is how it all began. In 2014, during a prize-giving day ceremony, the deputy governor of the county made an informal request to the school to allow Muslim girls wear hijab and white trousers in addition to the school uniform. Before the matter could be deliberated fully, girls showed up to school a week later wearing the items. What followed were a series of meetings between the school administration and ministry officials to resolve the stalemate without success. Then, the district education officer ordered the transfer of the principal for refusing to comply with their demands. This is what then prompted the Methodist Church to go to court. So what happened in court? This is in court where they decided to challenge that decision by the respondents to allow hijab contrary to their school uniform policy. Now, they also claimed that to allow Muslim girls to wear hijab would be giving them preferential treatment and thereby discriminative to the others, and that the order in itself was unconstitutional. The parent, Mr. Fugisha, had 2 girls at the school, applied to be enjoined as an interested party. In his affidavit, he said that the denial of hijab is indirect discrimination against his daughters and other Muslim female students at the school on their right to education on the basis of their religion. I want you to note that, because we'll come back to this later, as this was the bone of contention of this case. So this is what the High Court then ruled. They ruled in favor of the Methodist Church, saying the decision by the ministry officials was discriminatory, unlawful, and went against school rules. The judge ruled that the County Director of Education, the TSC, should not interfere with the Methodist Church in running the school, and then asked the ministry officials to ensure full compliance with the school rules and the regulations. In addition, they were told not to interfere with the PTA or the Board of Management of the school. This is important. The judge faulted the father's cross petition, saying he found it defective. So let's pause there for a moment, because the parent was then unhappy with this outcome. So what did he do? The parent appealed this decision, went to the Court of Appeal. The Court of Appeal then ruled in his favor. It set aside the decision of the High Court and directed the Board of Management of the school to amend the rules to allow students with religious beliefs to wear particular items in addition to the school uniform. They also directed the Cabinet Secretary of Education to formulate rules and regulations for the protection of rights under Article 32 and 27, both of which enshrine freedom of religion and equality and freedom from discrimination. It didn't end there. Aggrieved by this decision, the Methodist Church took this case even further to the Supreme Court. The judges there now set aside the orders of the appellate court. They faulted the appeal court judges for relying on the parent's affidavit, saying that his cross petition went beyond the issues raised by the original petitioner. That is the Methodist Church, that it was improperly before the High Court and therefore should never have been entertained by the Court of Appeal to begin with. They did, however, say this, and this is where a lot of people are upset with the Supreme Court. They said that they recognize that the issues that were contained in the impugned cross petition are important national matters. This is because the Supreme Court is the sole body that is tasked with interpretation of the Constitution. They said that the issue can be raised according to procedure at lower courts. Everybody is upset about this. Well, some people are. So what exactly does this ruling mean for Muslim girls in schools in Kenya, and where do we go from here?